Welcome, everybody. My name is Francesco Sindico. I am the director of the Strathclyde Centre for Environmental Law and Governance. And it is my great pleasure to welcome you to the last SCELG seminar of this year. And it's also a great pleasure because the speaker of this last seminar is a dear friend and colleague, Dr. Berti Suman. She has completed her PhD at the Tilburg Institute for Law and Technology last year. And it's really just when the pandemic started. I was lucky enough to be in her Viva, unlucky enough not to be there in person, but I was absolutely impressed by the quality of her research, of her work, and I'm really, really keen for as many people, both with us today and both people who will see this recorded, to really dive into her work and into her research because it's absolutely fascinating. She is now working in her postdoc research with the Dutch Research Council, still at Tilburg, but she is seconded at the European Commission. And she is also soon going to start a Marie Curie individual fellowship. She will say a few more words about herself, but I will give her the floor, Anna. She will speak for 30 minutes, and then we'll have time for a Q&A. As always, you can use the Q&A, the Q&A function to pose questions, which I will moderate at the end. As for the chat, I will close it now because I really want us to focus on Anna and really enjoy her presentation. But I will open it again when she finishes. And please use the chat at that time to introduce yourself, to say who you are, to get in contact with Anna, and also to share any resources, events, webinars, documents that are related to what we're going to talk about today, which is about the Formosa case and citizen science. So Anna, the floor is yours.
Yes, many thanks. So welcome everybody. And I'm actually currently based in northern Italy, living on Lake Maggiore. And I think it's also important to say where we are at the moment, because in this virtual environment, we tend to forget where we are based. So I'm very pleased to let's say, bring to you some of the lake vibe on like where I'm currently based. And I don't know how many of you are actually, let's say, familiar with citizen science, but I would like to trigger you with a poll. So are you familiar with the concept of citizen science? Yes, no, or a little bit. And the notion of citizen science is very broad, so I invite you to focus on the, let's say, on the notion that is closer to your current field. And we will soon have the results, let's say. So, okay. So at the moment, it doesn't move the slide, so I will just try again with the moving. So it's just not moving to the next slide, but I think it's a thing with the recording. So I'll be trying again with the, just 1 second, yes.
Sorry, Anna, can you see the results of the poll?
So myself, no.
Okay, so the results of the poll are that, are you familiar with the concept of citizen science? Yes, a 54%, no, an 8%, and a little bit, 38%.
Okay, so I guess it's quite balanced. So we do have some let's say, okay, now we can see it all.
I just realized.
So, fantastic. So more than half can know something about citizen science. And I think it's great because this will allow us to start. So, okay, I'm currently based at the Joint Research Center of the European Commission. For those that do not know what this research center does, we are basically developing science for the European Commission, so science for policy. But within this bigger frame, the Sensing for Justice project is like a small focused research project that will started this summer as a Dutch Research Council project and will later develop in a Marie Curie individual fellowship. So this is quite nice because it gives us until 2023 time span to develop this project. And the project Sensing for Justice is, let's say, it's an individual fellowship, but I am so happy to be working with a number of colleagues, such as Ben Schade, the scientific supervisor at the Joint Research Center, the whole team there, CI.A, which is a research center for the prevention of environmental conflicts, and also an artist, so the colleague that made all the wonderful drawing that we will see in this presentation. So the Sensing for Justice project researches the potential of citizen sensing as a source of evidence in environmental litigation, but also as a tool to eventually mediate the environmental conflict, because we know how long-lasting often environmental litigation are. So one of the points for those, let's say the small percentage that never heard about citizen science and even less about citizen sensing, a set the scene is that citizen science can be framed as all those instances where the lay public, so people that are not experts, not appointed from an institution, they don't come from a company, become engaged in scientific research for a number of outputs, for example, to steer policy, to influence companies, for scientists themselves. And citizen science is quite broad and has a, let's say, more neutral meaning, in the sense that it can be framed as health citizen science, environmental citizen science, and even narrower, radiation citizen science, air quality citizen science, and so on. And citizen sensing is kind of an even narrower subset of this broader practice and engages the public in really sensing environmental problems. And what I mean with sensing, I would say, I mean both the use of our own senses. So think to how important in these COVID times is our smell or our sight, the capacity to hear. So if you can imagine how much we frame the environment and we perceive environmental stressors throughout our own senses, we understand that in fact we do our sensors ourselves. And sometimes we don't even need certain technologies. It's enough to smell, to see, to become sentinels of the environment. And on the other side, this form of monitoring at times needs some sensors, so some instruments. And for example, in this drawing, you can see a citizen in Basilicata. It's a human being, let's say. It doesn't matter if you're a citizen of a certain country or a migrant or whatever, but it's important that you have some rights and you have some duties, and you feel the responsibility to monitor. And so this citizen in the image is using a radiation sensor and is going around to track radiation level in its own surrounding environment. So from this, we can build together the notion of citizen sensing as grassroots-driven environmental monitoring from below, so let's say from lay people, that is aimed to affirm some forms of claims. That could be a claim to a healthier environment, could be a claim to be listened by authorities, but could also be a claim vis-a-vis courts and tribunals. And so in a sense, what we are very curious to research with the Census project is which conditions are applied by court to accept or dismiss evidence provided by citizens in terms of citizen-generated evidence. And with that, I would like to launch another poll, which is more focused on, let's say, to what extent you consider the potential of using citizen-generated evidence in environmental litigation, even beyond the sensor, really about sight, about smell. And there is quite a tradition of using, let's say, this evidence. The only thing is that it hasn't been qualified as such, so not really qualified as citizen science. So let's see on this side whether it's something fully new for you or it's something that you heard. So, okay, definitely it's the majority. And I think this is quite interesting because it sounded to us that courts were kind of unprepared, not really, let's say, familiar with these forms of evidence from below. But it seems that among you, there are some, let's say, believers that this certainly has potential. So then, today, we will zoom in on a specific case. It's the Formosa case, and we decided to title this speech, this talk, this discussion as how this Formosa case can be a new horizon for the acceptance of civic evidence in environmental litigation. And I guess, how many of you knows about the Formosa case? So let's launch another poll. And so this case is a case of plastic pollution in Lavaca Bay, Texas. You may have heard about it. I was contacted some days ago by a colleague that said, I'm working on it. So it's interesting, but maybe some of you haven't heard about it. So I see that both options says, I have heard. So let's say that the first is I have heard about it, and the second is I haven't heard. So please vote the first if you have heard, and the second if you've never heard about it. I don't know, probably this with the results, I hope will be still meaningful. And of course, for those voting, I've heard about it. I would be very happy later on to discuss where and through which channels. So, okay, still there is a majority, assuming that those, that the vote was fair. There is a majority on having heard about it, and that's great. So we are, let's say, well positioned, at least for us. Okay, so the case is for those who are not familiar or not that familiar with the case. So the case started in June 2000. So let's say the case, we got to know the case in June 2019 with this groundbreaking court decision that fined Formosa for massive plastic contamination over years, and was in part based on the evidence provided by citizens. So, of course, this ruling was ongoing since 2017, and the work of the citizen in collecting environmental evidence was even dating back, as I will tell you how the plaintiffs kept accumulating evidence over years. Now, what we really were interested in was in disentangling, understanding citizen-collected evidence. So how this evidence were framed by the court, because for us, scientists looking at the case, we could define and label them as citizen-collected evidence. But in a sense, for the court, that was not their plane. They were applying just the same, let's say, the same scheme, the same criteria that were used to apply in all the other cases of environmental contamination they handled in the past. But this case has definitely some original traits that I will show you shortly. And among these, let's say, particularities of the case, we also try to extract some winning ingredients, so key factors that could have steered the judge towards a positive decision. And we, of course, acknowledge that there are some special elements of the case that are very context dependent, so very typical to the US scenario. But we try to extract some implication for European environmental litigation, and so also for communities in Europe that wish to have their civic data accepted in court. So the case was really impactful, and there's nothing we can say about that, because there were thousands of, let's say, evidence of contamination just dumped on the bench of the court case, on the desk of the judge. And it was not that only that impactful for the amount of evidence, but it was also so impactful for the media attention that the case received. If you think that there was a sort of key leader of the Citizen, Diane Wilson, which we had the opportunity to talk with, and she was featuring in a number of news outlets, in a number of newspapers, and so on, and attracted attention not only of media and scientists, but also of fellow communities and of the regulators, as I will tell you later. So this is definitely not a standard case in the terms that, in the sense that many civic struggles do not go so much in the open, in the media, and are more, let's say, silent, still very valuable. But this case definitely has among one of the winning ingredients to be a very symbolic case. So we tried to apply to the analysis of this case a sort of overarching question. So we wonder, under which condition can civic monitoring be accepted in court as a legal evidence of environmental wrongdoings? So we tried to search the case, looking for these anchors, these elements that could make us understand how citizen-generated evidence could be accepted in court in future rulings. And we had some sub-questions because the case was really complex. And so first we wonder which types of evidence counted as citizen science in this specific litigation. Because, citizen science is a very broad and, in a sense, vague term. And we really wanted to understand what was citizen science in the Formosa case. And then how the judge qualified that. Because what we qualify as citizen science may not be framed by the judge at all. And in fact, the judge never mentioned citizen science. So it's interesting because we try to interpret the ruling knowing that this is citizen science, but the judge itself, the judge themselves, they didn't really qualify it at all. And also, against which standards the judge assessed the admissibility of this evidence and their credibility. So, as I said at the beginning, the judge didn't treat them as specific type of evidence, like different from others. They just applied the same criteria that were the standard criteria. So, for example, the Dover standard on the credibility of expert evidence. And so, in a sense, these standards should apply also to citizen science, and then communities need to consider these standards as well when they want to approach the court's arena. And lastly, given that the citizen science evidence were not the sole evidence provided to the court by the plaintiffs, which role this specific evidence played, and what was the kind of entanglement and the mutual reinforcement of the various type of evidence, so also agency findings, company audit, testimony by qualified expert, and this is also an important trait, as I will stress later. So, originally, we focused on a methodology that was mostly, let's say, traditionally legal. So we looked at the case, we performed a case analysis, legal analysis of all the provision, especially the Clean Water Act that was mentioned by the case itself. And then from there, we realized that we needed to search further on two dimensions. One was the media, because the case appeared a lot in the media. So we started developing a media analysis on how the cases was received by a number of media outlets, including, for example, the Texas Observer, The Guardian, and other, let's say, outlets that also started calling other companies to watch over this ruling for potential consequences that it could have in other countries and other regions of the world, because Formosa is a multinational company, it's originally a Taiwanese company. And We also felt that we needed to engage with the plaintiffs. So we intentionally decided not to, we took the perspective of the plaintiffs, so we were interested in their perspective. Maybe in the future, we will consider writing a similar study from the perspective of Formosa, so of the company. But we also realized that Formosa was really silent in media outlets, so we didn't find a lot of, actually we found none official statement from the company on the ruling. But we tried as much as possible to stick to the text of the ruling and to consult the plaintiffs and their chief lawyer to kind of complement what from the ruling was a bit unsure or unclear. And that was an amazing experience because like talking with the plaintiffs and with the chief lawyer, Amy Johnson, we could also know all the background of the cases. So for example, the extent to which at the moment the Formosa plaintiffs are working on enforcing the consent decree, so ensuring that all the Formosa conviction is actually enforced, which is the most important aspect in a litigation, that the ruling doesn't stay in a drawer, but actually gets enforced. And of course, we could also discover way more nuanced information on, for example, how the plaintiffs went on collecting all the evidence over time. And for example, Diane told us her patrolling with a kayak of Formosa Bay, which also inspired this drawing. And it was a very choral collective effort, which we found also a big learning. And we had to systematize, let's say, the big the entanglement of various juridical, social, political concepts that the ruling was in a sort of table. So this table may sound a bit sterile, but we found it very useful to kind of organize all the elements of the case. And we also hope, as this is already happening, that other peer researchers will use this kind of grid to analyze further case where citizen science is let's say, admitted or at least enters the court arena. And of course, at the time we have this morning, I cannot really, let's say, dive into all the elements of this grid, but I just want to highlight some elements that for the lawyers in the virtual room can be very useful. So first, this is a civil law proceeding. So it's a proceeding for damage, and it was brought under the citizen suit authority provided by the Clean Water Act. And this is a special, let's say, legal resort that US citizens have, which may also differ from other jurisdictions. So for example, in other countries in Europe, there's nothing like the citizen suit authority, which basically is a more direct resort for the citizen to court without having to pass through the government, but just alerting the competent agency and directly suing the company. And the court was the US District Court in Texas for the Southern District. And the plaintiffs, and this is interesting, were a combination between basically individual fisherwomen and fishermen and local residents, all coordinated by an environmental association. And there seems an element, it seems to be quite important to have a sort of overarching realities that is kind of also steering the and coordinating the action, which is an element that maybe some groups of citizens a bit less organized may consider as a winning factor. And the case was brought against Formosa Plastics in Texas and the mother company is Taiwanese Formosa Corporation. The other interesting element is that there was really a woman, Diane Wilson, which is a fisherwoman, a very dedicated person that kind of dragged energy, attention, motivated peer residents and peer fisherwomen and fishermen. And all this, let's say, collective effort managed to get to the result that we are observing today. So the alleged violation, and this is very important, was a repeated violation of the US Clean Water Act for a systematic, persistent discharge of floating solids, basically plastic powder and plastic pellets, so-called nardles. So these little white little balls that you see floating in the water. And in Texas, in the bay, they were like massive. So it was visible even with bare eyes. It was not even needed to do any kind of scientific measuring, like a water measuring and so on, because they were visible with your own eyes. And not only this repeated discharge that violated Formosa permit, but also violation of reporting duties. And this is also very important because not only the company kept polluting, but also didn't report at all what was going on. And so basically breaching both the right to a clean environment by the local residents, but also the right to get and access environmental information, because basically the information was just not there, not provided by the company. And the plaintiffs were very skilled and organized in, let's say, systematizing and collecting evidence over years that they just collected in physical samples. So basically little bags full of these plastic pellets, together also with photos, videos, testimonies of the residents. But what is very interesting is that they corroborated this evidence with expert witnesses and admissions of the same defendants and of Formosa former workers, which is quite interesting because they could also have, let's say, the other side of the coin, not just the citizen voice. And also they used Formosa own audits and audits by the Texas Environmental Protection Agency that basically were kind of spotting Formosa wrongdoings, but not acting upon them. And another fully important, very important evidence was that the samples were collected on more than 500 days and in a sort of very structured manner. So they were not the residents waking up in the morning and going to collect sample, but they were really coordinating. There was a chain of custody that ensured that once the evidence was collected, somebody would record this and they would pass this information to the lawyer. And so in a sense, also this solid methodology and the standard operating procedures are quite important to then ground the credibility of the plaintiffs. And I'm sure Francesco will share the slides, so I'm not going into all the elements, but what is interesting is also the time span. So from 2016, the observation, to 2019. So it was really also in terms of timing, even more than what a scientist may have done. And so the decision was basically one of the biggest conviction that happened in the last years for environmental pollution, actually $50 million in, let's say, monetary relief and mitigation measures. And the courts, let's say the parties agreed on a consent decree and that the court approved. And now the consent decree is being enforced, which basically entails a number of remediation measures, but also more importantly, a number of intervention to support fisherwomen and fishermen in the area, because all this plastic pollution was basically very much affecting the daily life of these people that were living out of fishery, also their recreational value of the area. And now it's quite difficult to say what were the top winning factors, because I think by now you heard some of the let's say, great aspects of this case. But to us, from our analysis, what we can extract as sort of overarching lesson, one is definitely the fact that the evidence were relatively simple. So they didn't require any type of monitoring. So for example, in my PhD, I researched on air quality and radiation measurement. And both air quality and radiation entail the use of a sensor, because it's really difficult to say, well, this air is polluted unless there is a big smoke or there are radiation, because you need a sort of sensor to measure it. Whereas in this case, it was enough to have your own eyes and to basically, with your bare hands, collect the plastic from the water. So it was quite simple. And also, the simple type of evidence was linked to a very relatively simple type of standard, which was qualitative and not quantitative for environmental violation. So the permit issued to Formosa prevented Formosa to release in the water more than trace amount of plastic powder and pellets. And basically, the more than trace amount, it means that shouldn't be visible. And at the moment when it becomes visible, it's already more than trace amounts. So the only question, is it visible? Yes, it would be the standard violated. And this is quite important because also the chief lawyer of the plaintiffs told us that many other cases are not, let's say, that simple in terms of the standards to be applied, are more quantitative. So for example, a certain concentration of radiation, a certain concentration of polluter in the water, whereas in this case was really straightforward. And also the fact that various types of evidence like strengthen each other and let's say corroborated each other, which really made the case so strong. And lastly, the fact that there is a dedicated champion, this Diane Wilson, which was called as an unreasonable woman. So a person with great power, which was very inspiring for fellow citizens. And let's say also pushed the other citizens to perform this rigorous data collection over years, also with the support of experts. So basically what they did was what the Environmental Protection Agency was not doing and what the company was not doing. And they were not doing it in a very citizen manner, in the sense that they were almost as structured as scientists, but they were scientists. And so what it's really, really relevant is that the citizen collected evidence was not challenged at all in court. So maybe these winning factors combined made the court not even, let's say, question the credibility of this evidence, and the company as well. The company didn't even question the civic evidence. The only aspect that the company questioned was the expert testimony in support of the plaintiffs. That was kind of the company raised this double standard for credibility of expert evidence against these experts, but not really, that was in any case dismissed, but at all against the citizen-generated evidence. So that said, we can conclude that this case has certainly some very original traits. And probably there are some winning ingredients that are that could be used and could be applied to other cases. For example, the fact that communities striving to provide their collected evidence in court could, when they can, consider using a rather qualitative type of evidence rather than quantitative, because these are more likely to be accepted. And in a sense, this is a pity, because many contamination cases occur and need to be demonstrated through quantitative standards, so violation of a certain threshold. And this would make more challenging for these type of communities to assess the court stage and be heard by courts. Nonetheless, there are other elements that are, let's say, could be more universal and also easier to be achieved by other communities. For example, the fact of bringing in experts to corroborate their findings, or bringing in scientists, or taking also audits from the same company or governmental audits to kind of triangulate the type of evidence and show that all converge to a point. So the case is relative, but we think that, for example, for European environmental litigation, what we should do, and I guess we can also develop this further in the discussion, is to look, and I mentioned a suggestion that I got from Marie Pattern Petersman, a great colleague of mine now in Tilburg, suggested to look at cases where courts in Europe, for example, also the European Court of Human Rights, and why not also the Inter-American Court of Human Rights, basically used forms of citizen-collected evidence without classifying them as such, and even without the plaintiffs to brand them as citizen science. So in a sense, we should even maybe go back in history and look at how the courts reacted to this kind of evidence in the past. And at the moment, I think what we should do as legal researcher is to really support these kind of communities. For example, with law clinics, with for example, in the Harvard Law School, we are quite, let's say, looking at them with inspiration, because there is this Emmet Environmental Law Clinic that basically provided a Q&A legal support to communities wishing to litigate their cases with basically the support of the students. Or eventually, of course, it's not a paid service, so it can just be an orientation, but these people, let's say communities, can at least know whether the material they have, the evidence they have, is suitable for litigation. Lastly, this piece will be published on Citizen Science Theory and Practice journal with my co-authors Ben Schade. We will also extract a blog post that will be a little bit more accessible, because maybe this is quite appealing for lawyers, but not that much for community members. And let's say, before moving to the discussion, I would like to throw to you 3 points of attention. And I know the time is over, so I see Francesco in the screen. I have the last 2 minutes. One, it's whether this case, even for non-citizen science as experts, so the minority that said never heard about citizen science, is accessible, is interesting for you, how other academics or practicing lawyers would find it. Is it a case that can be relevant from other perspectives? Also, for us, it's stunning, but because it's really one of the first cases where citizen science was so much recognized in court, but without being recognized in a sense. So is it so stunning also for you from a different point of view? So for example, an evidence law perspective, environmental international law perspective. And lastly, which kind of parallelism can we build with other fields? Because we think that we really can learn a lot. And I left some web page and the Twitter handle. And the last element I want to mention is that we are quite, if you saw some drawing, is because we are quite vocal in trying with the Sensing for Justice project to find new ways, more visual, to tell our story and to discuss the notion of citizen sensing and the story of civic sentinels around the world. And so, for example, we produced these comics. It's a very short, you will see it's very narrow, and I never will publish a book like the thesis anymore. And this is really tiny, and it will be soon available for free on the Sentius page, the e version. But let's say also we will find a way to deliver hard copies soon. And in a sense, we're using these tools also for the communities we're working on, because we think this way is more approachable. So with that, I would like to conclude with a short poll to now understand whether after all these, you became more familiar with and more intrigued, possibly, with the concept of citizen science and also its potential for litigation. So I hope, let's say, all this discussion really made you intrigued, also made you more sensitive to instances of citizen science in your daily life. Because in the end, I mean, we are always surrounded by it. I think it's more a matter of recognizing it. Okay, great. I think that's a good result. At least no one said no. So I'm happy, and one maybe. So many thanks. I'll stop sharing here. And I'm very curious to see questions.
Thank you very much, Anna. That was absolutely fascinating. I had no doubts, but it's always a pleasure to hear your work. So I have my own questions, and I want to say a few words. Please, if you do have questions, this is the time to put them in the Q&A box. The Q&A box does allow you to upvote the questions, so I will take them in order of how many people like, let's say, the question. But first, just a note on Anna's research. So I didn't say a lot about her PhD work, but it was on the Fukushima disaster and citizen sensing there and so forth. And apart from being an absolute pleasure to read, the one thing that I find similar to the work that you're doing with the Formosa case is the fact of not almost aggressively going on the ground, even in COVID times where obviously, I'm assuming you didn't go to Texas, so you've done all of this online. But still, the point is, you understand research as needing to engage with those who were involved, be it in Japan with the Fukushima disaster, be it in Texas with the Formosa case. And I think that is absolutely laudable and absolutely incredible that you are able to do that. And obviously this can lend to ages of discussion, but there's so much logistics around it and so much time that I really think you do it, but also with a smile. You do it with as a pleasure, let's say. And I'm sure there are some problems there as well. But having said that, the 2 points I want to ask you, and then I'll also ask the ones in the Q&A, are why the Formosa case? I'm assuming this is not the only case around the world where there is citizen sensing in litigation. So the first question is why the Formosa case and not case X, Y, and Z in Argentina or Japan or Indonesia or Europe or so forth? And the second is more about the research project as a whole and your work. And I ask this because, as you know, here at XI.A, we are leading the climate change litigation initiative, where we are also interested in litigation, and we are really trying to share information about litigation as much as possible in a neutral way, without being for litigation, but talking about litigation. So my question to you is, when you're thinking of the project itself and your work, what is the final goal? One, is it mainly research to better understand how citizen sensing works in litigation? Or does it have a more policy/advocacy also focus? Meaning, do you want to advocate for more use of citizen sensing in litigation? Do you want to potentially even provide, through your work, through your research, legal advice on how to use citizen sensing in litigation? And the last possible option, I think, in my head, so the fourth possible goal of your project, but I'd like you to tell me what it is almost to start, if not a database, a collation of cases where citizen sensing is used to share with those who are interested in this topic. So I'll let you answer these questions and then I'll move to the Q&A box.
Thank you, Francesco. So these are great questions, and I'm sure we'll talk also more later. But so why the Formosa? I think it's a combination of serendipity, so the right case at the right moment. So it was the summer in 2019 where I had this question on citizen-generated data in court and so on, and then I read about the case. And it really inspired the project because I found a number of elements in that ruling that were so interesting to me. And one is the fact that it was based in the US jurisdiction, which is it's the only country in the world. The US it's the only jurisdiction where citizen science has been recognized in a legal statute. So there is the Crowdsourcing and Citizen Science Act. So there is a really legal recognition of citizen science, which, for example, in Europe is not. There is this staff working document of the European Commission on the use of citizen-generated evidence for policy, but there's nothing like a legal recognition, for example, in an Italian statute and so on. So this is getting better, but in a sense, the power of this act is undoubted. And the second is I think there are many cases where citizen science were used in court, but not as the evidence-based, the primary evidence-based. Was more to trigger litigation. So to enforce other experts, to inform other experts that would then do the collecting. And in this case, this was really the bulk, the bones. And the organized manner, the 3 years, the structured way really made it as scientific evidence. And lastly, I think the amount of money that they managed to get at the first attempt, 50 million, is really way more than what he expected. And also the way they are now enforcing it. So I personally come from the Ecuador cases of Chevron, Texaco versus Aguinda, that all these years and no justice and no enforcement. And to me, this was to me a case of hope, let's say. And there are many, there can be others, but I don't think many have all these conditions together. Our final goal, my final goal, I would say I'm very, very thrilled to create this database, because I think we need to study this field and compare cases. Of course, with the Sensing for Justice project, I mean, I think 3 years are not even enough, because I'm constantly reached by colleagues, by communities, like now recently with a great case in Chile, and they say, we wish to litigate with this evidence and go to a court. And it's so dynamic that I think this should be a project, but maybe it's a after census project, because I'm currently creating a database, but it's like the cases that me as an individual researcher I managed to fill in. But I think there is a big potential for a bigger database, which why not could be inspired by your own database at XI.A. And of course, we would like to steer, I think, mostly two aspects. Now, not much the policymakers, but really the peer lawyers, because we need more lawyers researching this and more lawyers that trust citizen science and are open to support plaintiffs wishing to use citizen science. And second, communities, because we think when we become more approachable to communities start approaching us. So I think I will be very satisfied if at the end of this year, I will have gave some wise advice to some communities for them to litigate the project. So I think this would be the best goal I have in mind. Yeah.
Thank you very much. So I'm afraid we're having some problems with the chat. I do apologize for that, but you do have Anna's contact information, and obviously I will share the slides afterwards and so forth. So hopefully that will solve a little bit the problem in the chat. So I have 2 questions in the Q&A, and I have a hand up amongst the participants. I would kindly ask, I cannot see who it is. So if the person who did raise her hand can just put a question in the chat, and I will then pose it to Anna. So the first question is from our colleague Kate at XI.A. So regarding the evidence collected over 3 years, was there a strategic or legal reason 3 years of evidence was needed rather than only 1 or 2 years worth of evidence? So a bit of a technical question, but maybe you can answer that.
Yeah, thank you. I think also these technical questions are very worth, because I mean, one of the first counter arguments that governments, courts make against citizen evidence is that it's not enough, it's too narrow the time. So I think it was more to be safer, and because basically they were collecting this evidence even from before. And then at one point they said, well, this is enough to start, let's say, systematically collecting this evidence. And I think they needed 2 years also because one of the arguments of Formosa was that this plastic was preceding Formosa. So that was kind of plastic that was already in the water before Formosa operation. And so basically starting from year 0, let's say the first year, and then up to the 3rd year, and seeing that plastic was increasing, and they started like over 2 years, they also started knowing the wind conditions, how wind would change, how fishes would change according to the plastic pollution. And so basically based on that, they could demonstrate that over 3 years, there was a massive change, let's say, in the amount of plastic released, but also in the conditions where other conditions were stable. So I think that was a strategic decision also to possibly counteract any possible, let's say, argument by Formosa that this was a preceding contamination and not Formosa responsibility.
Mm-hmm. Thank you very much, Anna. Then we have a question from our colleague Stacy. Stacy is based in Barbados, so this is quite an early webinar for her. She's very excited about the presentation. She's asking something about the nexus between human rights and environmental litigation. So the question is, to what extent is this case an example of an emerging jurisprudence which is unfolding and is cementing the nexus between human rights and environmental litigation?
Thank you, Stacey. Great question. And I would like to mention again a great conversation I had with Mary, which was a reviewer for this paper in a discussion we had at Tilburg. So one of the things we reflected upon on this paper is that in the ruling, interesting, the court doesn't mention any human right. And not even the right to access environmental information, which for us was like, it's a big pillar of the Census project, but actually focus on the, let's say, the value of the environment per se, and eventually for a recreational, but also aesthetic value. So clearly appreciated by humans, but without really mentioning human rights. So for example, the right to a healthy environment is not mentioned at all. And I mean, for me, I interpreted that as implicit. So basically, I had the impression that the plaintiff included it in their arguments and that the court kind of recognizing this aesthetic value gave it for granted, that it was functional to the development of rights by the plaintiffs. Whereas, for example, according to my colleague Mary Peterman, this is instead an argument for going beyond the human rights mentality as functional to granting environmental protection, but rather is a recognition of the value as such of the environment. So I wouldn't say that this is a case that is the, let's say, is the biggest example of recognizing human rights, let's say environmental litigation through human rights, because I think that the level of environmental pollution in this case was really beyond also humans. And I guess this is also a value and a strategy of the court. Honestly, I think that it was a massive breach of human rights to access environmental information, so to the ARUS framework. But I think different researchers may interpret this differently. So I can see that.
Thank you. And we have now 2 questions. So thanks to the participants for starting to put more questions in. We have 10 minutes. Okay, so Anna, I'll put the questions as quickly as I can, and you can give some fast and interesting answers to them. First one is from Amelia. Amelia is another XI.A colleague. Amelia has actually a very interesting practitioner background in the US. So she was probably very interested in this presentation. And her question, I'll just tell you the last part is, has your research looked at other places for citizen data to play a role? And is it possible these other types of provisions can reinforce the role of citizen gathered data in oversight and enforcement? And she explains why she asked this in the earlier part of her question that you can read as well.
Yes. In a sense, I think there are a number of other provisions where citizen-generated data could play a huge role. And I would like to say, for example, not only in statutes as such. For example, one of the pillars that here we don't really focus so much is the mediation potential of citizen science. So one of the key roles we think citizen-generated data could have is really to go to the company and show that that people have evidence of certain violation and kind of push the company to a settlement that doesn't even pass through the court. And of course, this has some limits because a judgment like Formosa is a big precedent. But for example, the role in mediation could be quite important. the other aspect is, for example, the ARUS framework, which as such is not recognized. Well, to my knowledge, it's not enforced in the US. But the ARUS framework, and I know many US scholars are actually interested in how in Europe we do enforce the ARUS framework. But citizen-generated data could be pivotal in affirming people's right to access environmental information, but also to participate in decision-making and to access justice. Because when the information is not there, there is a big vulnus, a big detriment to people's possibility to know exactly what's going on in their surrounding environment. So I think there are, let's say, a big pool of legal norms, but also of, let's say, social practices where citizen-generated data could play a big role. And I honestly invite all legal scholars in the room or interested researchers to look at their countries and see where citizen-generated data could play a role. Because, for example, in Ecuador, there is a great ley de monitoreo ambiental where citizens can use this law to monitor their Amazon lands. And that's very typical to Ecuador. So why not looking at, I don't know, Italian, French, German, and so on jurisdiction? So I would say that's it.
Let me pose these last two questions and then we can conclude. And I think I'll bring them together from Agung, Guardana, from Ben Cave, because to some extent, in my mind at least, they highlight two possible challenges with the use of citizen science. Agung talks about, he mentions Indonesia, but I think this can apply to so many other countries. And it's, well, what if the citizen science comes from the corporation side? What if a corporation, in whatever way, builds a community of citizen science for her favor? How does that work out in a case? And Ben asks about surveys. Can surveys be used as evidence? He has concerns that they're typically dismissed as subjective, for example, stress, mental health. So again, be it in the Formosa case, be it in other experiences that you have encountered, can you engage with Agung and Ben's points, and then we'll bring it to a close. Thanks.
Sure. Yes. So I think so citizen science coming from the company sounds a bit like an oxymoron, but not necessarily, because in fact, one of the concern is that this evidence becomes fabricated. And I was just discussing Wednesday with some colleagues, like, should we grant everyone the right to contribute to environmental information, even to the climate deniers, even to the Novaks? So then we may have a problem there, because when we say that everyone has this right, then also the company's supporters have the right to provide whatever environmental information they wish. What I would say as counterbalance and I, like as a sort of, so my approach is that citizen-generated data shouldn't never be considered alone. So should always be on hand in hand with an expert, with a scientist, with a governmental checkup. So in a sense, I would say the gatekeepers are the scientists and the governments that should be allegedly super parties. When we have corrupted governments, scientists that are in a revolving door system, that this can become more problematic. But then maybe another fringe of citizen scientists could counterbalance the company's citizen scientists. So to be short, I would say that information on both sides at least allows a balance. And then if we have the scientists from the company and the scientists from the citizen, at least we have the two sides of the coin. And then it's a court. The court will judge, or the government will judge. But it can be complex. So I think this is a great question. And on the second question, so surveys, I think it depends on how you understand surveys and for which kind of reason. So for example, I wouldn't use any qualitative survey on mental health because, well, it depends on the scope of your claim. But for example, if you're claiming that this current noise ongoing from this factory is disrupting my sleep, and I make a survey asking for that, and 90% of the participants say yes, I wouldn't say that this is like a clear-cut evidence, but at least is an orientation of perception. And I think citizen science sometimes includes not only, let's say, number science or values, but also perceptions. And especially in, for example, risk perception, health perception, also perception is quite important to as an element that a court needs or a government needs to act upon. So I would say, why not, depending on how they're framed, if they're framed by good methodologies that can frame them credibly, they can corroborate other evidence. Of course, they cannot be alone. Yeah.
So Anna, I did say I would conclude, but the last question from Catherine McKenzie is particularly interesting, and it's something that really interests me, and it's about the voice of children in citizen science, the way I understand the question. How do you see child citizenship collective voice in this regard? I'm thinking, if in the Formosa case, all the evidence, citizen science evidence, had come from 10 years old, would that have the same value or not? How do you see it?
I love this question, so thank you. And I would say it's very strategic to use citizen. We have seen in the latest litigation, in a sense, I haven't seen any case where young citizen scientists were litigating. So this is definitely something new to me. But I have to say that sadly, the demography, especially in Europe, of the citizen scientists is not that young. They are more likely to be towards pension people. And I think this is a great missed opportunity. So this is why I'm currently going to school advertising this, because I think the youngest need to be the most attentive sentinels. So I would say, I think with this wave of climate activists from the youth, there will be soon more young citizen scientists. And I think the climate field would be very promising for that. Because, for example, how youngest perceive the climate threat, I think it's very important at a qualitative point of view. And if youngsters start measuring, I don't know, changing weather, changing heat, or changing water levels, that could be powerful as much as like other type of expert evidence on climate. So yeah, promise.
Thank you very much, Anna. I will take this to a close now. I would like to thank all the participants to this webinar. I really hope that many more can see it once it's recorded, and we will put it up live on the XI.A YouTube channel. And also, this is the last webinar of this year. Obviously, it's been a challenging, difficult year, but at the same time, by using webinars, we have reached out to a wider audience than those who would be sitting at the Lord Hope building with us, or at the TIC, the building behind me. I really hope that next year we can go back to a series of XI.A seminars where we can sit together, when the speakers can have coffee with us really, and have a lunch and talk about their work and research. But I do think that the webinar format is also here to stay. And I will talk with my colleagues at XI.A on how to make the best of both worlds starting next year, and having both in person but also virtual at the same time to try to attract as many people as possible. Again, thank you very much, Anna, for joining us today from Lake Maggiore. And I hope that everybody has a safe summer, and to see you all again for the next series of XI.A seminars that will most likely start around October next year. Bye-bye, everybody.
Great. Thank you all.